Since the beginning of the case of Ripple Labs versus SEC in December 2020, you might have noticed how much irrationality this government agency is capable of. And what today's news makes clear is that it seems that we have not yet discovered the limits of this insanity. On the 25th of May, the SEC requested an extension of time in order to file an objection to the recent amici request by attorney John Deaton. But, before diving deeper into this topic, hello to the XRP news community, welcome to a new video. If this is the first time you see one of our videos, we send a special greeting, and we encourage you to subscribe to the channel and activate the bell notifications, so you don't miss any videos. I want to tell you that this channel gives away 200 XRP. For a chance to participate, all you must do is subscribe, like the video and leave a comment. The winner will be announced on the 31st of May. In addition to this, get 100 extra XRP if you are on our Telegram channel. The link is in the description. With that said, let's get straight to the topic at hand. Perhaps, as you know, last year John Deaton filed a petition to intervene in the case of SEC versus Ripple. The court denied the petition, but granted the status to 6 XRP holders. This means that they would be involved in the case as friends of the court and would submit briefs previously approved by the presiding judge. In earlier May, John Deaton requested the approval of Judge Sarah Netburn for her to grant him amici status. The petition may allow Deaton to file a brief on behalf of the 63,700 investors, as well as give him access to expert reports and deposition evidence in the current legal battle. As part of the legal brief, the outspoken attorney plans to respond to a written report from one of the SEC's experts, Patrick Doody, who claims to know what motivated XRP buyers to buy the asset class in 2013. The petition in question requested any expert, offered by the SEC, opining that retail XRP holders lack any consumptive intent when acquiring XRP, or any expert, offered by the defendants, providing testimony related to non-investment reasons to acquire XRP. Because in virtually all cases, this is information that someone with amici status should have access to. Observing the development, lawyer Jeremy Hogan said, John Deaton is marching into court. The SEC wants an expert witness to give testimony about what XRP holders were thinking when they bought XRP. Deaton represents 67,000 actual XRP holders and wants to present what they were actually thinking. So, of course, the SEC opposes it. Prior to the motion, many pundits, including Deaton, had criticized Doody's report, pointing out that he had never actually spoken to any XRP buyers before his statement came to court. Deaton also argued that if the SEC expert cared about investors, then he would know that this lawsuit causes them huge financial losses. Based on experience, it's expected that Doody will say that Ripple investors were motivated by the fact that they would make big profits in the future when they bought the token. In addition, and as we will see later, it is possible that he will have certain economic incentives to support the SEC's version. However, and not surprisingly, the SEC applied their delay tactic to avoid the participation of Deaton. The plaintiff requested an extension to file an objection to the recent amici request to participate in the expert challenge, and the court responded by granting it. Supposedly, the motion was to be ready on May 30th, but it will be ready on June 7th, because there is an upcoming national holiday. This might seem obvious, but the agency is acting unprofessionally, as it is willing to risk its own lawsuit just to delay things longer than is necessary right now. This is a waste of the court's time and will take a heavy toll on SEC in the future. Despite that, the defendants have informed the agency that they have no objection to this extension request, as long as the SEC agrees that any response by the defendants will be due by Friday, June 10, 2022. Nevertheless, if you think this was the only irrational behavior of the agency that came to light, let me tell you that you are wrong. Recently, the journalist and producer of Fox Business gave the scoop on her Twitter account. Patrick Doody, the independent expert that the SEC, is an employee of a private consulting firm that won a government contract of $4.1 million paid by the SEC. This fact was confirmed by the attorney Jeremy Hogan, who reacted to this by saying, "It does absolutely destroy his credibility, especially if it turns out that the $4.1 mil is a large percentage of the company's gross income." It may seem obvious, but we can consider this a bribe because the SEC is paying its expert witnesses to say exactly what the agency wants. I know, how on earth is this even possible? Let us remember that in countries governed by common law, such as the United States, it is illegal to lie during a trial. So, how can we trust a witness or expert who is financed by one of those involved in the case? Not only that, but also it was discovered that in the case against Telegram, Patrick Doody declared that he was co-founder of Lily Pad Capital alongside Joseph Alberts, a partner at Latham & Watkins and a member of the EA. This means Doody has direct ties to EA and Latham & Watkins, the firm that represented the Clinton campaign in 2016, of which Gary Gensler was head of financials. This exposes the blatant corruption to which the SEC is subject, not to mention the conflicts of interest that these activities entail. But all of this bodes well for Ripple Labs because their testimony will be more reliable in the eyes of the court. Even though this case is a challenge unlike anything that Ripple Labs has ever confronted before, the number of victories that this defendant got is notable. Moving on, let's start with the next topic. As you know, since its beginning, Terra showed UST as an algorithmic stablecoin directed by the law of supply and demand. All the same, the shocking collapse of virtually all Terra Luna ecosystems caused panic among investors. Many onlookers questioned if some stablecoins would suffer a similar state and wondered if the end had come for this nascent market. Furthermore, the collapse has drawn more than ever scrutiny from regulators, which are seeking to impose new measures on the cryptocurrency sector. Gary Gensler, chair of the SEC, recently assured investors that other crypto assets could imitate Terra's failure. Meanwhile, the South Korean National Tax Service has imposed a $78 million tax evasion fine on Terra's CEO, Do Kwon, despite the executive refuting these accusations. In this context, an interview took place on Fox Business, where Brad Garlinghouse shared that cryptocurrencies can survive after the collapse of UST. Also, he talked about the potential of cryptocurrencies and said that the clarity of operations has become more essential with the latest collapse of the UST stablecoin. According to him, a clear financial framework is a critical value in the crypto industry and noted that the industry whole could function well if this is provided. He put Ripple Labs and XRP as an example of transparent players in the industry, saying, "Well, I think the entire industry needs to be more transparent. I think that applies to Tether, and I think that applies to, the entire industry. From the earliest days of Ripple and the XRP community, we've tried to lead by example. We've really tried to be the adults in the crypto room." Among other things, Garlinghouse pointed out that he attended with the goal of sharing Ripple's mechanisms as part of keeping it transparent. "It's the reason I've come here to Davos and met with finance ministers from around the world, from CEOs of banks around the world, to talk about how these technologies can, actually, solve real-world problems and reduce costs and improve the efficiency of, particularly, cross-border payments." With this, the CEO was making it clear that blockchain technology reduces the costs of remittances. As a result, this potentially improves the efficiency of cross-border payments. That is why it is important that Ripple Labs succeeds in the trial taking place in the United States, which so far seems to be the only country whose government seems reluctant when it comes to opening up to cryptocurrencies. In the latest proceedings, the SEC refuses neither to confirm nor deny the existence of Bill Hinman in his famous securities speech of 2018 on the website of the agency. So we come to the end of the video. If you liked it, we would appreciate it if you subscribe to the channel and give a like. We publish a daily video. You should also share the video with someone that you think can be useful. See you in the next video.